Good afternoon, everyone, and thank you for joining us for a special edition of our webinar series, Inside Immigration. Today, we're joined by Managing Partner Stephen Green and Senior Associate and LMIA Practice Director, Ellie Slavens. The panelists will take some questions at the end of the webinar, so please feel free to ask any questions via the pop-up toolbar on the right side of your screen. If we do not get to your question, please reach out and we'll be happy to schedule a consultation. So with that being said, I'm going to hand things over to the panelists.
Great, thank you so much, Stephen. So today we're really going to concentrate on what is the new regulations that came into being this past Monday. And they really concentrate on the work permit situation. And the government of Canada for many years lately has been looking at the protection of temporary foreign workers that are coming into Canada. I'm sure many of you have read stories where certain employers really aren't fulfilling their obligations to a temporary worker, and the government of Canada wants to stop as much abuse and fill in the gaps that have been missing with respect to applying for work permits, and more specifically on the employer's obligations. And they've really expanded the obligation of an employer. And I think it's important to understand that there are employer responsibilities, and we're going to talk about those. And then there are the foreign nationals' responsibilities who comes in on a work permit to Canada. So one of the biggest changes that occurred was that the government of Canada wanted to make sure that the foreign worker understood the employee-employer relationship. So what they've mandated now is that an employment agreement must be executed as part of the process. And it's important that you as an employer understand your obligations with respect to employment relationships. And again, it would always be our recommendation that you seek legal advice with respect to an employment contract in order to protect you as an employer when you're dealing with someone who is coming in from overseas to gain employment in your establishment. So that's a big change. Before, we didn't require it in many respects, and it must be in writing. It cannot be orally between the two of the two people, the employer and the employee, and again in English or French, whatever the employee would like to see. So that's a biggie. And they'll ask for it in the LMIA application. Ellie tells me that they've already changed the application, and maybe Ellie will talk a little bit about that. And we always have questions. Oh, I completed my LMIA application last week. I'm ready to send it in. What do I do? Well, I think now, based on the new regulations, you really are going to have to execute a new LMIA, because there are statutory requirements that didn't exist before that now exist and are found within the LMIA obligations. So it's really important, in our opinion, that you seek legal advice when you enter into this contract, because an employee may take you to the Labor Relations Board, the employee may, sue you in court. So you want to be protected as much as possible when you get involved in the employment agreement. The second area is the inability of an employer to charge an employee for the recruitment process, for the fees involved in getting the LMIA. And it kind of, it makes sense, because as I stated at the beginning, the LMIA is an application done by the employer. It's not done on behalf of the employee. It's done on behalf of the employer to satisfy the Canadian government that that particular job that the employer is trying to fill is certified and they've met the obligations under the LMIA to get that certificate. So it's not specific to an employee, it's specific to the job that needs to be filled, the job requirements that need to be filled, and that's why they've really separated more so now the obligations under the LMIA process. But you know, a lot of times, more so in the low skilled area, many companies go ahead and use recruiters abroad. And if it comes to the attention of the Service Canada officer that people were paying the recruiter abroad, then you as an employer could be subject to some serious consequences under this process. So again, if you are using recruiters, you better make sure that your relationship with them clearly defines that they are not allowed to charge within the LMIA process for recruitment, that they're not allowed to charge the foreign worker coming into Canada that $1,000 application fee. And if the government finds out that you have used a recruiter that's done that, then again, you could be subject to non-compliance. You can be subject to a situation where you get a administrative monetary penalty. So you would get a fine, and there's a process to go through that. And you know, the end result could be that fine, could be your prohibition from using the LMIA process. So it's a very, very serious condition that you as an employer have to examine and make sure that there are not hidden fees being charged to the worker that's going to come up to Canada. And another area that they instituted is healthcare. They're concerned that, again, you know, a lot of it's concentrating on the low skill worker, but applies to low skill and high skill. That if you bring someone in, for example, as a farm worker working on your farm, they need medical treatment, there has to be some assistance with respect to the medical treatment. There has to be perhaps a phone on the farm that if someone is in distress, the foreign worker has the ability and understands you know, what's available for them with respect to healthcare. Now, when you know, we had the issue with COVID, many of the provinces eliminated the waiting period of 90 days. But now, with respect to COVID being more under control, we may see the provinces going back to a waiting period to provide healthcare to a work permit holder. And again, that places a higher obligation on an employer with respect to healthcare. So maybe I'll have Ellie talk a little bit about, you know, the new LMIA application, which again came out Monday, and some of the things that they're now asking for in that application that they didn't before.
Sure. So the forms were updated, I believe it was last Thursday, and we're converting all previous LMIA application forms that we had prepared for clients over to the new forms. And there are several new questions on the LMIA forms that are basically in response to these regulations. So on the first page of the high wage LMIA form, a question is asked of the employing entity, the employer, if they have ever employed a foreign worker under the Temporary Foreign Worker Program or the International Mobility Program in the last 6 years, and also whether they are an affiliate or related to any company that's currently subject to any administrative monetary penalties or ban on obtaining an LMIA. So those new questions have been built in. And towards the end of the form, they also ask the employer to confirm whether in their province it's a requirement to register with the statute relating to the protection of foreign nationals. So for example, in British Columbia, there's a requirement for employers to register and get a certificate of registration in order to hire temporary foreign workers under the temporary foreign worker program. And when they go through that registration process, it's about a 15-minute process to register. The licensing body will look at their compliance with other statutes. So let's say they have an outstanding workplace safety issue, that might be something they need to rectify and resolve before they can get that certificate of registration. The same could go for some sort of CRA transgression. So there's a process to get that certificate of registration. And right now, prior to Monday, Service Canada wasn't really asking to see that certificate of registration except for the province of Manitoba, despite the fact that it was a requirement in other provinces to be registered. So now on the new LMIA form, it asks the employer to check off whether the certificate of registration is required, and if so, that it's being attached and included with the LMIA application, or whether the province does not require registration or it doesn't apply. So there are 3 different responses on the form relating to those provincial obligations that are primarily employment law protections for the protection of temporary foreign workers. So there's an intersect between, employing foreign nationals and your employment obligations to them there. There's also a requirement both in the temporary foreign worker program and the international mobility program for employers to provide a handout, a pamphlet that the Canadian government is publishing to inform them of their legal rights. And they've created a website for those temporary foreign workers to go and to be able to educate themselves on what's available to them and, recourse if they're facing a situation of abuse. So the definition of abuse has also been expanded as part of the compliance regime. More protections there added. And yes, as Stephen was saying, it previously was a requirement to provide this replacement healthcare coverage for a low-wage LMIA application, but now it's a requirement for a high wage and under all LMIA streams to provide that replacement healthcare coverage. And on the LMIA form, you do not need to include the employment agreement when you submit the LMIA, but you're going to want to make sure that your LMIA mirrors the terms of employment that will be on that employment agreement, because you would be attesting on the LMIA form to the fact that you are going to provide an employment agreement to the temporary foreign worker before the first day of work in the language of preference, so English or French, one of the official languages of Canada. So, in order to complete the LMIA form, you don't want to have to go back and tell Service Canada, well, actually the foreign worker renegotiated and the salary is going to be X, or they are now going to be eligible for certain benefits. You're going to need to know what those terms and conditions of the employment relationship are going to be in order to completely and accurately fill out the LMIA form at the time, whether or not you've, the finalization and execution of the employment agreement is done or it's in the works.
And I would also, the point that Ellie brings up, that the government's going to provide a pamphlet with respect to the rights that a temporary foreign worker has coming into Canada. From a compliance standpoint, as an employer, I would want to have some document from that employee saying, yes, I understand the rights, you've provided me with the information where I can get it, so that if there is a compliance issue, you can say, well, wait a minute, we know we had an obligation to make sure that the foreign worker understood their rights in Canada, and here is a document that they have signed off on. So again, from a compliance standpoint, I believe that's very important. Also, which is new in the regulations, is that prior to these regulations coming in, if you had a compliance review, the inspection officer could write the employer and say, hey, could you provide us with the pay stubs to demonstrate that you paid according to what the LMIA is, or according to the employer portal, and the employer would then go ahead and provide this information. They had difficulty, however, in getting that documentation directly from a third-party service that provides pay on behalf of an employer. And many companies now, contract out their payroll to payroll companies. So what's happened under the new regulations is that the Service Canada officer, the inspection officer, the immigration officer that's doing this complaint can now deal directly without the approval of the employer with respect to the proper pay, the payroll, all of those issues. So you would want to review with that particular payroll company that you're working with to make sure that whatever information that you are sharing between the payroll company and yourself in the area of payment, that you're satisfied with respect to what can be released, because you will not even know. They are based on the authority of the new regulations permitted to go directly to the payroll company. So again, that's the second tip that we would say. Not only get the employee to sign off with their rights, but we would also encourage you to go back to your payroll company if you are using a payroll company and see what exactly they have, because you don't want to disclose information perhaps in some situations that a third party has. So that's part of the new regs. And another part I'm going to ask Ellie to talk about now is, you know, we brought out this national occupation of classifications, which basically the government tries to give a number to an occupation, define the skill type. Is it an A, an O, a B, a C, a D, and, you know, look at the skill level. Well, that's pretty outdated. And, you know, I remember when the NOC came out, it was, you know, great fanfare that they've updated everything from this old document called the CCDO, which was the Canadian Classification of Dictionaries of Occupations. So now they've decided to come out with a more up-to-date list of occupations, and Ellie will talk a little bit about this new system, and then talk about the healthcare field, because I'm sure many of you have been reading the difficulties that we in Canada are having with respect to healthcare providers. There's a huge need all across Canada, and obviously, the LMIA process is going to be involved a great deal with respect to healthcare workers. And Ellie really, as far as I'm concerned, runs a special department at our office that really specializes in healthcare workers. So she's going to talk a little bit about the healthcare area and this new classification.
Sure. So we have been assisting several clients with bringing foreign trained nurses to Canada. And because of the licensing requirements to practice as a nurse and be registered with the College of Nurses in Ontario, for example, there's quite a lot of red tape in terms of being able to bring foreign trained nurses here and get them working as nurses. So what we've been doing is bringing people here as nurse aides, which is a C-level NOC code right now, NOC 3413, I believe. And because of that C-level NOC classification, there are quite a few implications. So number one, wages are governed by a collective bargaining agreement, so that allows for us to be outside of the prevailing wage requirements for an LMIA. We have been under the low wage stream for those LMIA applications. And once we do get these bulk LMIAs and process the LMIAs, and then we go to the work permit side of things, we are getting some fast processing of the work permit applications because it's a priority occupation, and because there is a priority being placed on, getting healthcare workers in Canada. Some visa offices have been faster than others, but generally we've probably seen almost all of the batch of maybe about 45 nurse aides that we've filed in the last few months approved. So those people are starting to come into Canada, and some of them are they've all been doing their NCAA assessments, so they can determine which exams they can write, and then which licenses they might be eligible for. Do they need an additional educational courses to fulfill, practical work experience, etc. So once they arrive in Canada, those who are able to pass their exams and then get registered with the College of Nurses are going to have to be transitioned over from these nurse aid LMIA-based work permits to an LMIA-based work permit to work as a nurse. So that's a whole other LMIA application that will have to be submitted under the nursing NOC code. And nursing and doctor LMIAs are sort of focused out east with the Service Canada Centre of Excellence there. So there is a special unit at Service Canada that is looking at those applications in particular and understands things like, you know, posting on the Job Bank of Canada is not an effective method to recruit doctors or nurses, for example. So there's some flexibility there. And, you know, once those people are either here as nurse aides and may or may not be able to get licensed and then convert over to a nursing LMIA-based work permit, then we have to look at what their permanent residence options are. So in Ontario, we have the strategic occupation stream for the OINP that allows nurse aides to apply after 9 months of work experience for a nomination certificate from the province. Last year, I understand there were only draws in the early months of the year, and then sort of those died off and other areas were focused on. We anticipate seeing some more draws for the nurse aide occupation in the early new year. You know, the government does continue to say that they're placing a priority on that, but a big change that's going to happen with the change from the NOC 2016 to the NOC 2021 that's going to be implemented in November will be that we have this tier system. So instead of having the 5 NOC levels, the O, A, B, C, D, it's going to be tiers, and there'll be 16 occupations, including nurse aides, that will end up becoming eligible for the express entry PR application, and that will bring in another route to permanent residence, depending on, you know, when these people would be submitting their profiles. If they don't have a year of Canadian work experience, they would have to qualify under the federal skilled worker program still, but it's still a big change, and it will also assist some of these individuals who've come and who had tried to include their family members, but because they were coming to a C skill level occupation, there's no open spousal work permit ability for the family, the spouse, to come and join and get an open work permit, which we found to be a big problem, something that we were trying to liaise with government about, because, you know, you can't expect these foreign trained nurses to come to Canada and care for our aging population, but not give them the ability to bring their family. However, there is still a concern about, you know, ability to afford bringing over children and a spouse and affording the cost of, you know, living in Canada. But under the low wage LMIA stream, the employer is paying for the round trip transportation for these nurse aides and ensuring that there is affordable and suitable accommodation, which has also caused quite a bit of strife for some of these employers who are, you know, trying to find a place to live for some of these foreign nationals in some of the remote communities in Ontario, where the housing situation and the housing market itself is pretty much next to non-existent. So those are some of the issues that we've been working through with these long-term care homes and, you know, healthcare occupations. There's a change now where it's been acknowledged that physicians who previously had a problem applying for express entry PR because of the, you know, lack of a formal employer-employee relationship due to the fee-for-service model, that's going to be sort of corrected, and they're going to be allowed to apply for express entry, acknowledge that they don't need to prove an employer-employee relationship given their fee-for-service model. That's also come up a bunch of times on LMIAs for physicians that we've done, because, you know, you can't really advertise a prevailing wage or a wage range when you're charging fee-for-service. It's very complicated to reflect how much the person is going to be expected to earn as a physician who charges on a fee-for-service model. So yeah, generally we're doing a lot of nurse aid, soon to be some nurses, because there are few and far between people who've left Canada but were previously here and may have been registered with the College of Nurses. So we do some nursing LMIAs as well, and then some physicians and a little bit of policy sort of liaison and working with the government to try and see what we can do to kind of improve in this area.
Yeah. So I think also something that is important to understand under the new regulations is when an LMIA is assessed by an officer, the officer has an obligation to do a global assessment to determine if the entry of a foreign worker will have a positive or neutral effect on the Canadian employment situation. However, they've amended the regulations now to specifically state a finding that there is not a positive effect on the Canadian labor market if the employer is not providing the prevailing wage, or there is a possibility of an abused situation with a foreign worker. So for some communities, the prevailing wage sometimes is quite high and not normal in that community, and used to be able to make an argument that the officer has to look at the global assessment, things like that. Not possible anymore. It will be a bar from getting an LMIA if you don't meet the prevailing wage. So that's also something that is new, and you have to be aware of that. I guess, two of the other areas that we just want to talk about briefly, obviously, is processing. Processing, quite candidly, is quite difficult. The government is trying their best to increase work permit processing times. The LMIA process isn't so bad in Ontario. They're pretty efficient and pretty darn good. But work permits in certain parts of the world, quite candidly, are a disaster. So the government, is trying to fix it. We keep hearing more and more that, things are going to get faster. So hopefully they will. But again, from a planning perspective, as an employer, it's very difficult to plan, to be honest, with respect to the processing times of someone obtaining a work permit. And I guess, some good news, as of October the 1st, the government of Canada is changing the entry requirements with respect to medical issues in the sense of COVID. No longer will people be required, as of October the 1st, today you still do, have to fill out the ArriveCAN app. It will be up to you if you want to fill it out. And some people will perhaps want to fill it out because it may expedite their entry into Canada from a CBSA point, from entry based on that. But no more Arrive Canada, no more masks on planes in and out of Canada, and
You don't have to be vaccinated.
You do not have to be vaccinated anymore.
Or testing, no testing or quarantine.
And no testing. So they're trying to make things better. I don't know if that's a better or a worse, but at least, many of the business communities have indicated over and over again that the ArriveCAN and the random testing has certainly affected people's willingness to come into Canada. But, now we're going to see what's going to happen from the passport processing situation, because now they've lifted ArriveCAN, they've lifted vaccination. So those whole group of Canadians that were reluctant to travel abroad because they didn't want to get involved in the vaccination process, they didn't want to get involved in the ArriveCAN, they didn't want to wear a mask on the airplane, now don't have to. So has Passport Canada prepared for this onslaught, perhaps, on October the 1st for people to travel? So we'll have to see. And I think that's really it, unless you have anything else to add? No, I think we're good. We have one question, does Green and Spiegel work with employers who have approved LMIAs? Absolutely. We do that. And remember that LMIAs have to be used within a certain time. So it's important that if you as an employer have an LMIA, you file that application either at an embassy or consulate abroad, or if you are visa exempt, you use that LMIA and enter the border at the time. So I think we are good for today. We thank you for attending. Stephen, do you have anything to add?
No, I was just going to say, for the first time ever, we barely have any questions. You must have been able to break down a complex area of law nice and simply for everyone, which is wonderful, wonderful to see and hear. I'd just like to provide a quick outro and thank you, Stephen and Ellie, for providing today's expert webinar. Your time was greatly appreciated. I'd like to thank everyone as well for attending today's webinar. If anybody would like to discuss the details discussed, feel free to reach out and book a consultation. We would love to discuss the details in more detail with you. And I'd encourage everyone else to sign up to our alerts and follow us on social media to keep up to date on the latest developments inside Canadian immigration. And until next time, everybody, stay safe. Thank you.
Thank you.